SJC-12652 in the matter of an impounded case.
Ms. Kaiser, good morning.
Good morning, Your Honors. My name is Jean Kaiser. I'm here on behalf of the appellant mother. The appellant mother asked this court to reverse that part of the juvenile court's ruling granting access to the trial transcripts of the C&P hearing to the parties. The mother opposes release of the transcript in its entirety, but today I'd like to focus on two parts, the mother's testimony and the testimony of her psychotherapist. The trial court abused its discretion by merely quoting from this court's previous decision in care and protection of MC when it balanced the relative interests of the parties. And it's easy to see that first with regard to release of the mother's testimony to the Commonwealth. If the Commonwealth can simply state the material nature of the mother's testimony in order to get access to the testimony, the chilling effect that this court acknowledged was very problematic in the previous case remains, because a parent who is facing both termination of their parental rights and criminal charges will face a very difficult decision. They can either decide not to testify in the care and protection trial, which would vastly diminish their ability to prevail in that trial.
What about the father with the third-party culprit, though?
Well, with regard to the father, it's a somewhat different analysis. The father claims that he needs the mother's testimony because it would provide exculpatory evidence. That, in some cases, it may be true that the other parent's testimony might provide exculpatory evidence. But in such a case, the other parent should have to make a threshold showing of why the evidence is exculpatory. Now, that shouldn't be a difficult thing to do. The father sat through the trial, and while he can't share the impounded documents with his attorney, there's not a gag order. He certainly can share what the mother said during her testimony with his attorney.
Can we go back to the chilling effect? Are you done with your answer to Justice Lowy?
Would it still have a chilling effect?
No, I'm sorry. Are you finished with your answer to Justice Lowy?
Yes.
Okay. On the chilling effect, I thought what was discussed in MC was the chilling effect of having that Hobson's choice of either providing testimony and mounting the defense, and then what the government wanted to do, have that testimony be admissible in the trial. And the analog, of course, was a motion to suppress. And what we had said was, no, the testimony would not be admissible in the criminal trial. The only way it would be admissible would be to impeach if there's a discrepancy.
Right, and certainly this court's prior ruling about the admissibility of the testimony ameliorates the problem somewhat, but it doesn't abolish the problem altogether. And you can see that here. We still have to balance the parties' relative interests. That's the heart of the good cause analysis, is a balancing test. And there's still a chilling effect if the mother has to decide whether or not the Commonwealth whether it's worth testifying when the Commonwealth can discover her testimony.
Well, she just can't lie.
Excuse me?
She just can't lie. Isn't that what it says? That it's only admissible to impeach.
It is only admissible to impeach. However, whereas here, the Commonwealth has said, well, we want to review her testimony, and why do we want to review it? We want to find, quote, investigatory links to heretofore unknown relevant evidence. It's very clear that the Commonwealth intends to use the parent's testimony as a discovery tool. In essence, what it's engaging in, if it receives the testimony, is a fishing expedition. Maybe there's something in there we can use.
What is it that, what showing must the Commonwealth or the parties make? Because you're saying, well, there's this chilling effect and it's not appropriate. When would it be appropriate to turn it over, in your view?
Well, I think it would be different for the Commonwealth and for the father. For the father, I think he would have to make a showing that there's actual exculpatory evidence. Here, the father has simply said, well, we plan to blame the mother for the crime. And all that the father has really been able to come up with in that regard is to say that we had a traditional family relationship and the mother spent more time with the child than I did. I was working. That does not seem to rise to the level of exculpatory, especially given the father's ability to communicate what the mother said to his defense attorney.
And what about for the Commonwealth?
With regard to the Commonwealth, I think the obvious reason why the Commonwealth would need the testimony would be if the mother decided to testify at trial. Then it would be admissible for impeachment purposes. But the Commonwealth should not be able to get the testimony months in advance simply because of a just-in-case rule. Just in case she testifies, the Commonwealth should be able to have the testimony and use it as an investigatory tool. What could have happened here is that the trial court could have granted the motion conditionally. It could have said, if the mother does decide to testify at trial, then come back, we'll have the testimony waiting here for you, we can expedite its release, and it can be used for impeachment purposes. That would have balanced the rights of the parties in a more effective way.
Similar to Rule 14 with the psychiatrist?
Yes, exactly. And
Or the old federal Janks rule, right? If you know the testimony's going to come in, then you get it.
That's exactly right, Your Honor. And the trial court did acknowledge that that should be the procedure. Now, the child and the Commonwealth both say this is an insurmountable burden, it's going to delay the trial, but I don't think if the motion was granted conditionally, it would have to be there'd be some delay, but not a long delay.
So why should the balance be different here than it would be for a motion to suppress? Motion to suppress, the Commonwealth hears the evidence. There's nothing that bars them from deriving leads from it, but they can use it only for impeachment.
Well, the motion to suppress is different in two important ways. First, it's not impounded testimony because there's not the same level of privacy consideration. But even more importantly, a motion to suppress would almost always deal with one particular part of a case, whether a search was valid, whether someone should have been given their Miranda rights before the police talked to them. Here, the mother's testimony is very far-ranging and had to do, as this court acknowledged, with many aspects that were not related to the criminal charges. And so here, the Commonwealth would be getting so much more than it would be looking at in terms of a motion to suppress.
But as it relates to the issue of character and the investigative reports and the GL, which weren't ordered to be turned over, to the extent there was testimony about that, presumably that wouldn't be admissible. I think what the judge was getting at was the real similarity when you're dealing with child abuse, medical child abuse, the real similarity between the C&P and ultimately what's going to be the criminal trial applying the MC good cause standard.
Well, there certainly are overlapping facts in this case. There's no question about that. But the question really is, if we compare the Commonwealth's reason for wanting the testimony, which doesn't seem to be anything more than maybe we'll need it in case she testifies, which could be handled in a different way, or we would like to be able to use it as a discovering tool, which I would argue is improper and would chill.
When you say discovery tool, are you looking at more than just whether she's going to be making the same statements at the criminal trial?
Yes, because, and these are not my words, these are the Commonwealth's own words.
So what is it that you think that they're looking for?
Well, it's difficult to tell, and I'm not sure the Commonwealth could even tell you what it's looking for, because it certainly has not laid that out in its motions to the court.
So if it wasn't looking for anything other than her testimony for purposes of impeachment, would it be all right?
If it wasn't looking for, I would think that makes it problematic. The Commonwealth should have to identify, and truly, I can't imagine what the Commonwealth could want her testimony for other than for impeachment purposes.
And if they want it for impeachment purposes, my hypothetical is if they want it for impeachment purposes ahead of time so that they can understand it, but they're not going to use it to develop any leads or fish, as you call it, would that be all right under this
Well,
test?
I think it would be very difficult to say you can have it, you can read it, but you can't use it for anything else.
But as Chief Justice Gantz pointed out, we do that all the time with other things, including some motions to suppress where there are impounded matters and confidential informants or witnesses who have to testify in camera.
That's true, but again, in the hypothetical I'm going to throw out right now doesn't relate to this case. It's just hypothetically what a parent might testify to in a case that they would not want the Commonwealth to have easy access to. For instance, if the parent kept a diary and testified in the care and protection hearing in an attempt to preserve their constitutional right to parent their child, the parents surely would not want the Commonwealth to find out about that. But release of the testimony way ahead of time, months ahead of time, just in case she might testify at the trial, would disclose that. I think there are all sorts of scenarios like that, given the far-reaching nature. And I think, too, the problem with the, just in case she testifies rule is then it applies to all cases. So if, I can imagine myself counseling a client before they made the decision whether to testify at trial, I would be faced with saying, well, look, if you don't testify, the judge can and will hold that testimony against you. And it's particularly difficult in a care and protection trial because it's not like a criminal trial where the defendant decides whether or not to testify. In a care and protection trial, it's often DCF that calls the witness to the stand, the parent to the stand. The parent is usually the primary witness. And in those cases, the parent would be required over and over again to assert their Fifth Amendment privilege. So you can see the chilling effect that this could have. And if
That's important, and it's one of the 7B factors. Maybe, let's just say it's the most important 7B factor. It's not the be-all and end-all. There's other factors, and let me just point out one of them in response to one of your comments. How about the Commonwealth wants to be able to understand the medical exhibits and or the medical documents? And in order to understand them, they need the testimony of the mother. They need the transcript. Now, I understand that the constitutional rights is one of the 7 factors, but it's not the only one.
Well, first, Your Honor, the Commonwealth did not say that's why it needed the testimony of the mother so that it could understand the medical testimony. And it's a little difficult to understand why the Commonwealth would need that, given that it has access to medical experts, all of the DCF testimony, all of the medical records. A care and protection case should not be a discovery bonanza for the Commonwealth to prosecute the parent.
I'm thinking back to the days when I was a federal prosecutor living under the Jenks Act, which we never imposed, but there was always a compromise. We'll give the statements to the defendant 3 days before or 7 days before. Would something similar make sense here?
So I think the good cause analysis is not a split the difference type of analysis. It's a balancing of rights. But in terms of that one limited reason why the Commonwealth would want the testimony, I would say that perhaps there could be some sort of agreement mapped out as to when the mother was going to decide whether to testify and when the Commonwealth could get the testimony. But I don't think the whole scale release of the entire transcript, including the therapist testimony, which I haven't had the opportunity to talk about, but the whole scale release of the transcript months before the trial, which is what the trial court did here, fits that bill.
Your time is up, but I do want to ask you, why should the father not get the therapist testimony? He was there to hear it. It was your client waived her therapist-patient privilege as to at least him, since he heard it. Why can't he get it?
Well, this court did say in MC that when a parent introduces testimony, their privacy right is reduced, especially to the with regard to the father who was there. However, this court also said that that was not dispositive. You need to weigh the factors. So here in this case, I think the father has to provide a reason why he wants the testimony. Here he says it's exculpatory, but again, even despite sitting through the psychotherapist's testimony, can't really explain why it's exculpatory.
But do we really want, I've been on both sides. It's pretty hard for a judge to identify piece by piece which bit of testimony is going to turn out to be exculpatory unless you know the entirety of the case, and that's awful hard for a judge. Is that fair to ask a judge to do that?
Well, it's a little fairer in this case because of the judge that heard the motion also sat through the trial, but that's why the father's counsel should have been able to identify that for the judge. And I would just say as a final, in terms of compromise, if the trial judge did think that the father had sufficiently, and again, the trial judge did not decide this case based on the father's claim of exculpatory evidence. A review of his decision shows that he really didn't consider that. But in that regard, if the trial judge did think that the father had met some standard, perhaps what he could do is somewhat of a Dwyer-type proceeding where he could have the father's counsel, criminal counsel, come in, read over the testimony, identify those parts of it which might be exculpatory, and then provide those parts, if in fact they did meet that standard.
But the attorney would have to see the entirety of it anyway in order to do that, would he not?
Yes, but I think what we need first, which we do not have here, is ruling by the judge that the father has met his burden of showing that the evidence was exculpatory. On its face, the trial court here, the father identified specific exhibits that he identified as being exculpatory, which were not released. So clearly, the trial court did not make this decision based on the exculpatory nature of the evidence.
Following up on Justice Lowy's question, or variation of it, if we decide that a party, the Commonwealth or the father, gets the testimony, should we not also say that they get the exhibits which were part and parcel of that testimony? So that, especially where there's reference made to an exhibit, or I guess in one case there was something there was a chart and the person was testifying from the chart.
Well, I think that that requires a far more nuanced view of whether the parties have met their burden under the good court standard and what pieces of evidence are related to the testimony. We don't have that here. I think what the trial court did is almost kind of split the difference, say, here you can have the testimony, but you can't have the exhibits, which, again, I think demonstrates that the trial judge abused his discretion.
Can I ask you just a practical point on this? If based on MC, if we were to say there's a 7-day rule or whatever rule, what about the really thorough ADA who gets it 7 days in advance, then goes through it and says, geez, there's a search warrant in here, let's go look for the diary. What's the difference between getting it 7 days versus 30 days versus 60 days in advance of trial?
Well,
Or at trial, where
I would not advocate.
well, I know you have to obviously you're bound and you don't like it, but
Right,
by
right.
MC1, so
Right. Right. So I think that rather than giving it 7 days before trial or 3 days before trial, I think it should be closer to the time that the mother would decide whether or not to testify. I would promote that once the mother does make the decision to testify, she notifies the ADA, and at that point, the testimony is waiting for the ADA. There may have to be a short recess so that the ADA can process that, but when you balance the respective rights of the parties, so that I think would be a fair result.
But I mean, pragmatically, most defense counsel will say, we're not going to make that decision until the Commonwealth rests.
Right, and that is a defendant's right. But I think, there will be some cases in which a parent who testified at a trial will at a CMP trial, will also testify at a criminal defense trial. But I think that's the rarer case when you consider the great differences between a criminal trial and a CMP trial, where the parent really has no choice but to at least get on the stand.
No, you asked my question.
Could I just want to go back, if I could, for a moment to my first question, because I'd like you to have a chance to respond to the argument. The father is going to say, well, this is third-party culprit evidence, and my theory is the mother did it. How can you say this doesn't satisfy good cause? What's your response?
Well, I think again, the response to that is that's the beginning of the father's showing, that he has a theory that the mother did it. And then the father, who has sat through the trial with an attorney, should be able to file an affidavit that says, on information and belief, the mother's testimony contains these three things, or something of that nature, that would tend to vindicate the father and inculpate her. This case has been around the bend twice, and the father has yet to do anything in that regard except to say that the family had a traditional structure. I don't think that rises to the level of exculpatory evidence. So I think it is quite feasible that a parent in another case could meet that threshold standing. I just don't think that the father here has. And again, even if he had, that's not why the trial court released the records. It's very difficult to see from the face of the trial court's decision why it made the decision that it did, but it's not apparently based on the exculpatory nature of the evidence.
All right, thank you.
Thank you very much.
Mr. Blumer, good morning.
Good morning, Your Honors. My name is Mark Bluver. I represent the father in this case, and appreciate the opportunity to speak with you all this morning. I think I want to go off script, if I could, and pick up on the question that you were asking, Justice Lowy. When the care and protection case, when they began that trial, I believe, in the spring of 2016, I went to the juvenile court and explained to Judge Collins that I wanted to be able to sit in. Mr. Conley had a court-appointed lawyer for his CNP, and I was not that lawyer. I was the criminal defendant lawyer. And my request was denied. And the CNP lawyer, attorney named Nathaniel Tripp, who had filed an affidavit at the conclusion and after MC1, when we went back and renewed our motion to get access to material that we thought was critical to Mr. Conley's defense, he identified certain exhibits that he thought were exculpatory, but because of the ambiguity about whether or not he could speak with me freely, he erred on the side of caution. And other than putting that affidavit in at the juvenile court, he demurred any conversation with me about the impact of the testimony, his analysis of the testimony in any way. So as I said to this court back in October of 2017, it raised an issue that is sort of underpinning this, that Mr. Conley, because he is indigent.
Again, avoid use of names. This is an impounded case, so it's just the
Excuse me, Your Honor. The father, because he was indigent, did not have the ability to have me sitting in that courtroom. Had he been a person of wealth and means, I perhaps would be in a position where I could address more directly the issues raised by Attorney Kaiser in terms of a level of specificity. I imagined that.
Didn't the judge not let you in because it was a closed proceeding?
And I didn't have an appearance, yes. But he knew that I was representing the father in the criminal case.
How did not
I
have
don't
any
get how
money?
I don't get how the indigency has anything to do with that. If the judge says, I've got a CMP attorney, I've got a criminal attorney, CMP attorney stays for CMP, criminal attorney, you don't.
What I imagine.
I get your points about the exculpatory,
Yeah.
I understand those, but I'm like,
No, I think
probably
that
not central
if
to
the
your
person
argument,
was at means, he could have had two lawyers in the CMP case. I could have sat there. I mean, again, in some fact. In any event, trying to speak to the question that Justice Lowy raised and the criticism raised by Attorney Kaiser, we tried. But there's something different. Yes, there is no gag order on the father. He and I have had conversations. We believe we've made the requisite showing to show that it was material and relevant. And as the court pointed out in MC1, of course, that's not the answer. That's not the be-all and end-all. If, in fact, after I see the material, if we believe it fits under the third-party culprit doctrine or it's exculpatory for some other reasons, then I go to the Superior Court trial judge and I say, Your Honor, this is what we propose to seek admissibility in the criminal trial, and only then, if the judge rules in our favor, only then would that material from either the psychotherapist or the mother's testimony would have to be handed over to the Commonwealth, consistent with the rules of discovery. So I think we've made the requisite showing based on the factors that were enunciated by this court in MC1, and I think that the judge below agreed. What was a little surprising is, and the part that I am talking about here has to do with the exhibits. Any of us who have tried cases and are looking at a transcript, to not have access to a document that a witness is either being shown or a document that a witness is commenting on, it would almost make that testimony indecipherable.
I couldn't follow the judge's ruling on that. Was this discussed in the hearing you had with him, why he would allow you the transcripts but not the exhibits?
It was not, and I was thinking about that before argument, talking to one of the clerks of this court. I probably would have immediately gone back and asked the court to clarify and file a motion for reconsideration, but the first notice of appeal was filed almost immediately, and it made that procedurally difficult. It just struck me and my co-counsel in the criminal case as particularly, well, actually, I thought it was a mistake. I didn't think it was, that's how I viewed it. I viewed it as a mistake. And that leads to a discussion about the GAL report and the court investigator's report. I agree with this court in MC1 that in the ordinary case, those reports would probably not fall into what I call the disclosure basket. There are issues that are being discussed in the run-of-the-mill criminal case are usually quite different than the issues that are before a juvenile court judge in a CMP proceeding. Yet in this case, I think there's a difference. And that difference has to do with the theory that was underlying the Department of Children and Families petition to sever custody, and it is the same theory that underlies the Commonwealth's prosecution. There are assault and battery charges in this case. They fall under 265.13J. I know Justice Budd, in your decision in Dracata, is at issue in this case in terms of what the father did, what the father didn't do, what he was aware of or what he was not aware of. Those GAL reports and the court investigator reports in this particular case we think are material and relevant because of the underlying prosecution theory, both in the criminal case and in the C&P. And one of you mentioned it, this concept of medical child abuse, or sometimes referred to as Munchausen. What that does is it puts what it would ordinarily be lifestyle issues front and center. Who was the person who communicated with the medical personnel? Who was the person who communicated with the special education teachers, with the principals at the school? All of these issues, which ordinarily I would concede probably don't have much of a bearing in a run-of-the-mill criminal case, have an enormous bearing in this case. And for those reasons, I would hope this court, when it renders its decision.
But wouldn't your client know who did that?
Of course, but
Right,
this,
so.
and that he's told me.
So you're saying that there should be, the GAL should testify to hearsay? I don't get that. part
No,
of it.
no, no, this goes.
It's not like
this
it's
is a
not
co-
undiscoverable absent, because you kind of have a good source about this.
Let me, if I could, Justice Gaziano, let me read to you something that was said to the judge below. It's in the supplemental appendix at page 63. This was the Assistant District Attorney speaking to the judge below. And it's page 63 of our supplemental appendix. There are, I would imagine, she says, and she refers to the court investigator specifically, I know they came to the district attorney's office. I know they went to the police department. I would imagine they went and spoke to most of the other witnesses that we have, referring to Commonwealth witnesses. All I took from that is that this investigation was done in hand in glove with the Department of Children and Families. The fact that we don't have any Rule 14 statements from the people that are obviously referenced in that statement indicate to me that the district attorneys, investigators, state troopers, ADA herself, spoke to these people, but they didn't memorialize those statements in writing.
Because part of the inquiry is whether or not these documents or this information would be discoverable by other means, correct?
And we have tried. I mean,
But I take what you're saying about the Munchausen by proxy and the lifestyle issues. But here, the other means would be the person who's sitting next to you at counsel table.
To some degree. I mean, again, there's a level of sophistication that has, a variety of things that might be particularly important to the father and really resonate with him, might not be the same things that resonate with myself and my co-counsel in the criminal case.
Can I ask you a question? Do you have
course.
a position on whether we should allow the same discovery for the Commonwealth as we do for you?
I think we stand on different foundations, Justice Lank. And I don't particularly have a position relative to what the Commonwealth is seeking. I think there's some practical issues that this court was asking Attorney Kaiser about how you give a trial lawyer access to something right in the middle of trial, and when you have a jury in a box, and how that may be a practical delay. But from my perspective, the difference between where I stand and where the government stands is that we wish to use this material defensively under the doctrine that was set forth in Commonwealth v. Santiago, the third-party doctrine. We don't wish to use it affirmatively, and which is what I believe the Commonwealth intends to do.
Can I ask another practical question? Assume for the sake of argument, I'm not sure we will, that we are persuaded by your argument as to at least some exhibits. I think you said that the GAL and the investigator's report were made an exhibit?
I was reading a footnote in MC1, Justice Gantz, and it appears, I think it's footnote 5 in the first decision of this court, it does appear that some of the court investigative report and the GAL report were admitted as exhibits and some were not, because in that footnote there's a quotation from the court below.
Okay, so let's assume for the sake of argument, again, we haven't discussed it, so I don't take any meaning from it, that we're persuaded that you get some exhibits that relate to what you need in order to understand the testimony of the witnesses whose testimony you're getting, but we're not persuaded by the GAL or investigators' report argument, and maybe not as to some other exhibits which may go beyond the scope. How do we avoid a remand to the trial judge, which I gather nobody wants?
You gather correctly. In fact, I was going to close with a request that the order that comes out of this court, hopefully I've persuaded you that the material that we're seeking, the court agrees. But whatever order comes out, be clear and unambiguous, so that we're not back on MC3. May 20th of this year will be the 4-year mark since the criminal case began in the district court. We are moving what looks like, for the father, a criminal trial in October of 2019. This is not set in stone by any chance, but based on the hearing we had last week. And I know the Commonwealth and the father, we are anxious to proceed, but from my perspective, the defendant's perspective, we are looking for the material that would ensure, in the words of Dwyer, a constitutionally fair trial.
Okay, but...
I don't know if that's a
well,
sufficient answer.
Again, I'm speaking pragmatically. If we say you get some exhibits but not all, is it for us to determine which exhibits you get? Do we go back to you and say, can you reach agreement as to what those exhibits would be if we were to articulate a standard? How do we do it to avoid a remand that nobody wants?
I would like to be able to tell you that we would reach an agreement with the Commonwealth, but we've been arguing about things for...
She's very reasonable.
For 3 years. Although not with Assistant District Attorney Lynch, who has just joined the case. Again, I'm not sure why the court would want to split. Again, the fact that we would just have access to the material, the fact that we would be able to read the material is just the first step. And whether or not that material is ultimately admissible, that's for Judge Kerry in the criminal case. So I think that as an officer of the court, we would take the material. We understand it's the possession of, and it's owned by the juvenile court, and we would use it for the limited purpose of preparing for trial. And we would move in limine if we thought that material needed to be presented at the criminal trial.
Thank you.
Thank you.
Ms. Lynch, I've already said you're reasonable, so...
I'm going to do my best, Your Honor. May it please the Court. Assistant District Attorney Bethany Lynch, representing the Commonwealth in this case. This case, obviously, as you know, arose out of the remand from MC1. And it's the Commonwealth's position that this court's mandate in MC1 was clear and unambiguous. A standard was set out for good cause. Multiple factors were set forth. They were not limited to those factors, but factors were set forth for the motion judge below to consider. Commonwealth would argue to this court that the motion judge in the juvenile court considered each and every factor and weighed them and balanced them appropriately. At no point did this court in MC1 state that any one factor was stronger or was to be weighted more heavily than any other factor. The motion judge was also the CMP judge, so he was as familiar with the record as any other party to the case, more familiar than most of the parties, because the Commonwealth has not seen the transcript. We do not know exactly what the mother or any of the witnesses testified to. And one of the primary factors in this case is the fact that the CMP was based on the identical conduct that is the foundation for the criminal charges against both the mother and the father. The nature of the controversy, while the perspective is different, it all deals with the parenting of this child. And as I agree with the father's attorney, Attorney Bluver, that this case stands slightly different because it is a Munchausen by proxy or medical child abuse case, so more than one specific act are at issue. And in this case, the actions of the parents surrounding this period of time that is the basis of the indictments against them, it was also the same period of time that is our understanding formed the foundation of the CMP hearing. At this point, the Commonwealth is looking for copies and access to the transcript. We respect and understand the court's ruling that the transcript in and of itself would not be admissible. But this information is necessary for the trial preparation for the Commonwealth. Multiple witnesses who we understand testified at the CMP will be called at the criminal trial in this case for all the parties. And prior recorded testimony to see how they testified previously is essential for the Commonwealth to prepare witnesses.
For impeachment purposes only?
I'm sorry?
For impeachment purposes only?
Most likely, yes, unless there was some other basis which it would be difficult to articulate without having the information in front of us.
Not
So-
for investigatory purposes?
Not for investigatory purposes per se. If there were, say, to take the example of the diary, if there were a mention of a diary, at that point, the Commonwealth having not been aware of it, I don't think anything would preclude us from attempting by motion to try and obtain a copy of that. But there's nothing mandatory in that. All we would have found out that would be at all negative or inculpatory, not even inculpatory, but anything we would have found out would have been that a diary exists.
But aren't you interested in the division of parental responsibilities? I mean, this is going to be a finger-pointing exercise, right? I assume you're going to want to really understand who's doing what in this relationship. So it is for investigatory purposes too, right?
More in terms of understanding purposes rather than investigatory. I don't know that from there we would then, to understand the relationships, yes, as they were put forth, and I guess possibly we could. It's very difficult without the actual information to know and to theorize as to what use we would be able to put the testimony. Without the testimony, our hands are tied. We can't.
As you speak, doesn't that beg for a Rule 14 Jenks type procedure? Because I get how if you get the mother's testimony, and as Justice Kafka mentioned, it's a treasure trove of information that you didn't otherwise have, and well-intended as you are, your office is, and you say, oh, we can only use this for impeachment, but oh my God, look at this.
But then
It's the look at this that is the concern, and if we just said because of the chilling effect, and it's admissible perhaps for impeachment purposes, isn't that a Jenks Rule 14 type issue?
I can see the point that you're making, but I would argue that even if there was a treasure trove of information, the use that we can put to it in terms of admissibility at trial, it's clear we can't use this as, it's not admissible at trial.
All right, so suppose the mother testifies, there was a next-door neighbor who I was very close with, we'd have coffee every morning, and I would tell her all the stuff going on with the kid. You didn't know about the next-door neighbor, and then you get the transcript. You're telling me you wouldn't tell a police officer, go interview the next-door neighbor?
I'm not telling you that. Yes.
Okay.
Again, without, I had not thought of that example, without seeing what's in it.
It's her
which is-
diary example, but yeah.
Right, I mean, I hadn't, yes, if there was a mention of an exculpatory neighbor or an inculpatory neighbor, something along those lines, but I think that all of those concerns that the court has about to what use the Commonwealth could or could not use the transcript, and at this point, we're just talking about the transcript of the testimony, all of that is subsumed within the good cause standard that the judge considered. He considered what use the Commonwealth, why the Commonwealth needed the transcripts, or why the Commonwealth, in order to prepare for trial, in order to adequately address testimony, and to know what witnesses were going to say, and to have information of that type. All of that, I would suggest to this court, is subsumed within the good cause standard.
Let me ask you about that, if I could, please. So, one of the good cause factors is the reason for the request. So, is the diary or the next-door neighbor example a permissible or impermissible consideration on the reason for the request factor?
I think it would be one reason. It would be a factor that could be considered by the judge. And if the lower court judge said, you know what, I don't think that's appropriate, the Commonwealth shouldn't use it for that, it would weigh that on the side of the balancing test that says not disclosure. The judge could have crafted his order in such a way. I would suggest to this court that in MC1, the balancing test says, here are all the factors, and all of this should be considered, and it should all be balanced, and it should all be recognized, and then the motion judge below comes to a determination as to whether or not he finds that there is good cause to release some information from the impoundment order for the limit, just to the parties for the criminal case. So again, the idea that there's no public disclosure of any of this information. None of this information is information that the father doesn't already have, that the mother hasn't put forth in a proceeding. And I understand that there's a difficulty in terms of the decisions that she was facing, but in terms of privacy issues, in terms of constitutional rights, all of those things were addressed within the motion judge's decision. He said that he gave careful consideration to the constitutional rights involved here. He said obviously the privacy issues for the mother obviously are important to his determination, but in his balancing test that he applied, he weighed other factors as well and found that other factors tipped the scale in favor of establishment of good cause.
And this is in context of the juvenile judge being the judge who presided over the hearing and knowing what the content of the testimony was.
Exactly. Yes, he was there. He knew everything that happened, and he found that the extent of the community interest could not be overstated. He weighed heavily additional factors beyond the Rule 7B factors, including the wishes of the child, whose privacy interests, I would suggest, are as great as, if not greater than, the mother's in this case, because it's her information that is the basis of the CMP and her medical information, all of that evidence, and she, through counsel, is in favor of disclosing it limited to the parties. And also the impact of.
How do you reconcile, what is your understanding of why the judge separated out the exhibits from the transcripts? Do you have a theory?
I don't have a theory on that.
And what is your view on that?
At this point, I would suggest, just for practical reasons, that the parties be given access to the transcripts, and because at this point, we don't have any idea what the exhibits are. So it could be certain exhibits that we don't need access to because we have them through other avenues. So I would suggest that just for practical consideration at this point, we could receive the transcripts. I believe that we could work together to try and assess what exhibits we do not have access to currently that were part of the CMP. And if we were not able to come to an agreement, then I would suggest at that point we could go back to the juvenile court judge and address the matter with him.
Can I go?
The therapist, if there had been no CMP hearing, you wouldn't have had access to the therapist's report until the mental state of the mother was put at issue. Why should you be in a better position because there was a CMP?
Well, I would agree that we would not have access to it at this point until later, but that information would never have been provided to any court prior to that. At this point, it's unlike, say, a Rule 17 or a Dwyer, where we're looking for documents that are not already exhibits in another court proceeding, or testimony that's not already in a court proceeding. In this case, the mother did put her information, her medical state, and she testified, as did her therapist, and she waived the privilege for that proceeding. I understand that it was limited to that proceeding in terms of the admissibility of that information later in a subsequent proceeding, but in terms of the accessibility, I would suggest, of the Commonwealth to those documents, I would suggest that that waiver be weighed heavily in terms of allowing the Commonwealth access. She voluntarily put that information into the CMP, and I think that's where there's a differentiation. I think that had that not been part of the CMP, you're absolutely correct, we would not be entitled to that information. But because it was, and because she allowed her privileged psychological and therapeutic records and the testimony of her therapist be a part of that CMP, that puts it in a different standing than it would if we were just looking for those documents and no CMP had ever occurred.
One last question, although I interrupted Justice Snowy. The one part of your brief I didn't get is that you made reference to prior recorded testimony exception.
I think that was
You told
more-
us that you recognize that it would not be admissible. I don't know what, are you contending that you could get it in at trial even though the person did not testify if it was a prior recorded recollection
I'm
or prior recorded testimony?
I put that in a footnote just to kind of highlight to the court that without the transcript, we don't know if there might not be another use to which we can put this information. We don't know. We don't know. And I'm not talking about necessarily the mother's testimony, because we understand her testimony can't come in as prior recorded. But the mother is objecting to the transcript as the entire thing, I believe. So there could be other witnesses, there could be parts of testimony. I think that until we know what the transcript says in terms of other uses to which we may move in limine to admit portions of the testimony, not necessarily just the mother's, we can't say that there's no other reason. I understand, it is confusing, but I'm saying that without it, we can't say that there might not be some other basis that some part of the testimony may be admissible.
Yeah, quickly, on the reason, I'm still stuck on the reason for the request and whether it's permissible or impermissible to look into the neighbor or the diary issue. It seems that in a medical child abuse case where the CNP is going to be very similar to the trial, if that's a permissible factor, that really chills the mother's willingness to testify at the CNP, and then the mother loses the chances to keep her child because she's afraid that her testimony might lead to a neighbor or to a diary. And I'm just not sure what to do with the reason for the request in this situation.
Well, I think it would be very difficult to fashion any kind of an order that would allow the Commonwealth any kind of access and to say you can't use it for anything but impeachment.
Why?
If there's something in there like a witness, the Commonwealth, I would suggest, would need to look into that. But again, I don't see why that can't be a factor to consider. And in the mother's opposition, I don't believe to the Commonwealth's motion for access to this information, I don't believe that that was a large argument that she made, that it would, not that it wouldn't be chilling, but that all of this other information, I think it puts the Commonwealth in a difficult position to say, if this is in there, then you can't have it. But the trial or the motion judge knows what's in there. So he can use that information and use that as part of his analysis. I guess that's the best way I can answer that question. I'm sorry.
All right, thank you.
Thank you very much.
Mr. Cohen? On behalf of the child.
Yes, good morning. May it please the court, David Cohen on behalf of the child. So the child asks you to affirm in all respects the ruling of the juvenile court below, allowing in part access to the impounded documents, denying in part, basically for reasons you've already heard, because the juvenile court judge applied the direct cause standard that this court announced in MC a year ago and ran through the analysis, considered the factors weighed the alternatives, came up with a result that was within the range of reasonable alternatives, and therefore there was no error and no abuse of discretion. I'll try to move directly to some of the questions that I heard come up here and see if I can give a little help there. But essentially, the ostensible legal issues that are raised in this DR appeal were decided by the MC case that this court has already decided. There are a few nuances that are coming up here that I'll speak to. So, father can make a third-party culprit defense in his criminal trial. Nothing is stopping father from making his third-party culprit defense. And in fact, father, in terms of the exculpatory information, if there is any, as has come up here, father is in a perfectly good position to know what that exculpatory information might be and use the criminal discovery process and other processes. He sat through the CNP. He co-parented the child. He should know where mother was. He has access to the medical records through the juvenile court granting access in this limited basis, so he can address, which doctors and which nurses on which day, where was the child, was the mother with the child, who met with the child, and this doctor's appointment, that doctor's appointment, or who interacted. So the father can make his third-party culprit defense, and we can infer from the juvenile court's opinion that the juvenile court decided there was no need to give father access to all of the exhibits, all of this information that was not, the juvenile court, as has been said here, did not specifically identify or consider exculpatory. Okay, in terms of then the trial exhibits, part or whole or all, child would suggest really that issue is premature and doesn't need to be decided by this court. As I think Attorney Bluver mentioned, he considered going back for a motion for reconsideration to say, well, I need this exhibit or that exhibit. And in fact, since father will have access to the transcript, it's premature for this court to order that from above. Justice Gantz, as you said, well, we think you should give access to this exhibit or not that exhibit. This court's not really in a position to do that. But father can go through the transcript, and if he has reason to say, I can't understand this testimony without this exhibits that's referred to, he can go back to the juvenile court. There's nothing to stop him from doing that. So that's how child would suggest a resolution of that issue. The mother's therapist testimony, I think child would agree with the Commonwealth there that in a certain sense it's no longer confidential. The privilege hasn't been waived, but father has heard it, and mother has put it into a court proceeding. So she has some diminished expectations of privacy, again, consistent with MC about that. I'm not sure I have an answer for your question, Justice Lowy, about permissible and investigatory considerations and what particular examples, other than to say that, again, the juvenile court judge was the same juvenile court judge that heard the trial, that was quite familiar with all of that evidence, and is in the best position to make that determination. This, of course, is primarily round two of a contest among mother, father, and the Commonwealth. But the child is, at this point, supporting what is, essentially a middle ground. On the first go-round, the juvenile court had granted all access, essentially, to everything. On this go-round, the juvenile court has restricted that. And child also would say is not in favor of a remand and is wanting to move on with her life, but would support in some fashion, if this court wants to affirm, which I was suggesting, affirm the juvenile court's order, but would support some restrictions on enforcement of making that information public. I think mother asked for it in the reply brief. Protocols like not copying, the attorneys personally inspecting things, having some kind of tighter rein by the juvenile court. Maybe this court could make a recommendation for that, because it does seem as if some of this information, child is supporting the good cause standard being applied properly, some information being granted access to, some not. But child does not want information to get out willy-nilly, and if some stricter protocols that wouldn't, they don't fundamentally disturb the good cause analysis, they don't fundamentally disturb what the juvenile court has done, but provide additional protection for the child's privacy.
Thank you.
Thank you very much.